The presenters for today's webinar will be Sami Schilly and Gary Nelson. Sami is an associate in Lewis, Roca, Rothgerber, Christie's Intellectual Property Practice Group. She has a broad practice that covers all aspects of intellectual property, including patent, trademark, and copyright. Much of her practice focuses on IP enforcement, takedowns, and litigation. Gary is a partner in Lewis, Roca, Rothgerber, Christie's Intellectual Property Practice Group. Gary's average day consists of waking up, picking a fight with an infringer, and then negotiating coexistence, even if the infringer does not exist by the time we are done negotiating. I will now turn it over to Sami.
Thank you, Sabrina, and thank you all for attending today. So I will be guiding you all today through some of the budget-friendly tactics that we typically use to take down infringers, and then Gary will be chiming in with additional commentary throughout the presentation. So you can kind of think of me as the play-by-play commentator and Gary providing color commentary. So before we dive into the more cost-effective approaches for addressing infringement, we wanted to touch briefly on the more traditional approaches for rights enforcement. So the first and more typical approach is sending a cease and desist letter after you've been able to identify the source of an infringing product and identified contact information from them. One of the bigger drawbacks in sending a cease and desist letter is that it requires cooperation by the infringer. If you send a letter to someone asking them to stop infringing on your trademark rights, they need to agree for the cease and desist letter to be effective. If the infringer does not respond or responds that they do not intend to comply, you then either need to follow up or may want to consider escalating the issue.
And at this point, I thought I would comment a little bit on the types of cease and desist letters. Because when we send out cease and desist letters, tone is very important part of the letter that goes out. And there's a whole scale of tone that we send out, but pretty typically there's three. If we identify a counterfeiter, then we're very aggressive, almost maybe even strident. If we decide to send out a cease and desist letter to counterfeiters, because sometimes counterfeiters are hard to actually locate a physical presence, and so it's actually sometimes not even feasible to send them a cease and desist letter. But if we can find them, then it's a very, very aggressive cease and desist letter. If it's someone who's less egregious than a counterfeiter, the tone is pretty much objective, very strong, very still aggressive in what we're asking, but not strident, but just objective. And with some of our clients, we actually come across infringers who we refer to them as brand fans, and that they're using our mark because they love the brand. And so the tone for that group of infringers is very sweet, and where we thank them for being such a fan, explain why we're reaching out to them. We have to enforce our mark, and by them doing what they do, and they endanger the validity of our trademarks. And being such a fan, we're sure they don't want to do that. And generally that's type of an explanation works quite well. And but in each, regardless of the tone of a cease and desist letter, generally there's two things that we absolutely want to do. We want to show them and convince them that we have the rights that we're claiming. And usually it's a trademark registration certificate. It falls under the power of the printed word, as opposed to trying to explain to somebody that you use the mark and you have common law rights. You just show them a trademark registration, and you really probably don't have to say anything else. People tend to understand, okay, whoever sent this letter has rights. And we also like to show the infringer exactly what they're doing that we object to. I can't tell you the number of times when I get a cease and desist letter for a particular client, the letter doesn't tell me it's complaining about some activity that the client is doing, but they don't tell us what they're doing. And so the first response is a reply saying, you know, there's nothing we can do until you tell us what you're complaining about. And likewise, when I receive some cease and desist letters, if they don't prove to me that they have trademark rights, the first response is, prove to me you have trademark rights before I take you seriously. And so that's pretty much the cease and desist letter stuff, in a nutshell. So back to Sami, I think.
Thanks, Gary. And Gary touched on this a little bit, but another consideration with cease and desist letters are that, often with sort of the Superfan approach, we send a friendly cease and desist letter because you should always assume that any communication can be shared on a website or social media. This is a viral age. Anything you say can certainly pop up online and could be detrimental to the brand if you come off as insensitive or unreasonable. And so with a cease and desist letter, carefully crafting the cease and desist letter is very important, which can also be extra important during the pandemic, where there are a lot of unfamiliar and new pressures, economic and other sorts of things. So when sending a direct cease and desist letter, you want to make sure that if this is published online, that you are not embarrassed by anything included in the letter.
And let me jump, Sami, and say, that really applies to the brand fan phenomena, where a brand fan is more likely than any other type of infringer to post the cease and desist letter online. And so we're fully aware of that, and that's why it's a very friendly yet insistent, almost apologetic but insistent way of going after that. So I just wanted to jump on that or add to that.
So another traditional approach would be to commence litigation, which I'm sure we all know can get very expensive quickly. In litigation, fees accrue quickly for both sides. So sometimes filing suit can put pressure on an infringer who doesn't want to fight the suit. That might be sufficient to make them go away quickly. But the rights owner is also likely to incur a lot of fees just with commencing suit. And so in the current economic climate, that might not be feasible.
Yes, and that's not really the core of this presentation. However, there are situations where litigation, you might want to consider litigation, and it's particularly applicable in two situations where the pretty solid evidence and confidence is high that whoever the infringer is based in a foreign country, and you can't find them. And if you file litigation, you fully expect to receive a default judgment. And then that also applies to certain situations in the United States itself, where there's people are hiding behind social media protection walls. And one example is we have food clients where the infringer actually has infused the food with cannabis oil, and so it upsets the client quite not surprisingly, but they're hiding and they don't want to be found, and so when they get sued in federal court, they generally results in a default judgment. So if you think you need a default judgment, litigation might be on the table. That's all I need to say about litigation.
Thanks, Gary. And as we both sort of touched throughout that, cease and desist letters and litigation will typically require identification of the source of the infringing products. And sometimes that can be difficult. People have gotten pretty good at hiding. In the past, you could typically look at the information for the registrant of a website, but with the GDPR, General Data Protection Regulations, privacy protections on who is, that's becoming increasingly more difficult. And so sometimes there's additional legwork that's required in order to identify the source of the goods. So a little more background, why are we here talking about this today at the end of July 2020? Throughout the coronavirus pandemic, brand owners have been impacted by the pandemic, resulting in tighter budgets. Consumers have also increased the frequency of online purchases, particularly consumers under stay-at-home orders or who just don't have the opportunity to shop in a physical location. And one downside to the bulk of shopping being performed online is that there's not an opportunity to inspect products before making a purchase. Consumers are also seeing their personal budgets impacted. So consumers who have been pining for a particular pair of jeans for a while, and then see an advertisement that they're now 75% off, they see a great deep discount, they might not question the validity or whether or not this is a legitimate website because they're just so excited to have the opportunity to buy these when their budgets are being hit by the pandemic as well. So this has created a golden opportunity for counterfeiters who have seized on the vulnerabilities of consumers and rights holders. U.S. Customs and Border Protection has reported an increase in counterfeit products across all U.S. ports. This has included PPE type equipment, including infringing logos. In June of last year, during 2 different raids, both in the state of Louisiana, the CBP seized about 2,000 counterfeit Gucci, Chanel, Burberry, and Supreme masks. And we're also seeing a significant uptick in the actual PPE, so separate from branding, but the PPE itself being imported into the U.S. As counterfeits. A few more statistics. As of June 1st, the CBP had seized more than 107,300 FDA prohibited COVID-19 test kits, 750,000 counterfeit face masks, 2,500 EPA prohibited antivirus lanyards, and 11,000 FDA prohibited chloroquine tablets. So we're certainly seeing a significant increase in counterfeit products across the board during the pandemic. In the online arena, we've also seen an increase in phishing scams, fake charitable websites, and price gouging of legitimate products. So what are some of the options that you have for addressing these different types of infringements on a budget? So we have found that Instagram, Facebook, Twitter, TikTok, and other social media platforms are often used to attract and trick consumers. The social media accounts.
Sami, let me jump in. Just quickly, it's like a lot of what we do today, but Sami and I do today, is on social media websites, taking down people who have an objectable presence on social media presence. But it was like the days of yore. When the infringement used to be in the brick and mortar stores that would show up, on the street, and then after a while, it became the online, people with online websites who were operating a retail store, their own retail store, and that's where the infringement took place. And then pretty soon then there's online websites, but when you go to the websites, it's a counterfeiter. It looks just like your website, or maybe it doesn't look just like it, but if you didn't know what your website looked like, you would believe that it was your website. And then the infringement tended to migrated again, and it became to the online platforms like Amazon, where a lot of infringing activity shows up. And then flash forward again, and then we're into social media, and that's where we do a lot of our enforcement is on social media. So in my experience, I've seen the progression from infringement going from brick and mortar stores all the way through the social media avenues now. And when you get to social media, it's not necessarily the volume of product that is being pushed. It's just that it's an online presence. It's akin to someone taking your mark and advertising in a very obvious and prominent way, but not necessarily the volume of infringing products. And so that's maybe some context for the social media enforcement activity. So, Sami?
Thanks, Gary. And yes, so one reason that we think social media accounts tend to be a popular choice is that there's no cost to create a profile. There are some costs associated with maintaining a website, but anyone can pretty quickly and easily establish a social media account, begin posting images of their products, and provide like a contact number or email, for example, saying if you want to buy this, contact me. Or as Gary mentioned, it's a great platform for advertising. We find that counterfeiters often devise creative usernames. They'll usually use a variation of a company name or one of their well-known trademarks. They might adopt company logos as their profile picture, and they'll often use hashtags to drive consumers to their accounts. So the social media platforms all have an internal mechanism for reporting trademark and copyright infringements. The basic requirements for submitting an infringement report, a trademark infringement report, is registered trademark rights in the pertinent jurisdiction, a link to an example of the trademark owner's use of its own mark online. This is often just the trademark owner's website. It could also be the trademark owner's own social media account if that's easier, or the mark is used there. Links.
Sami, I think there's a question that has popped up and I think might be appropriate to answer at this point. What the question is, you mentioned that your trademark rights are registered in the pertinent jurisdiction. The question is, what if the pertinent jurisdiction is the European Union and you have a U.S. registered trademark? And I think the answer to that is, for the European Union, it certainly is possible that establishing U.S. rights will be sufficient to enforce at an ISP or a platform that's based in the European Union. So the answer is maybe it works. It's certainly worth trying. If you get to a more obscure jurisdiction or obscure country, then the odds of a U.S. registration being sufficient is reduced. So anyway.
Thanks, Gary. Yes, and I completely agree. If you have trademark rights in the pertinent jurisdiction, that's going to be the strongest case, the most straightforward, most likely to not be rubber stamped, but as they're reviewing the report, that's the easiest one to act on. Whereas if you don't have registered rights in the jurisdiction where the party is located, certainly possible to still have it taken down. There just might be some back and forth with the platform explaining, for example, that the products could be imported into the U.S. They're advertised in the U.S., that this is still affecting you in the jurisdictions where you do have registered rights. So continuing through the requirements for submitting a report, you also need to provide a link to the offending post or the account on the social media platform, and a brief explanation of the infringing use. So that could also be an area where if you don't have rights in the pertinent jurisdiction, you could explain with the explanation of the infringing use why this is still problematic and threatens your rights in the brand. You're also required to submit a verified statement that the use is not authorized by the trademark owner, the information in the report is accurate, and the person submitting the report is authorized to act on the owner's behalf. And a few of the platforms will require a power of attorney for outside counsel to submit a report. And
Sami, another question that came in. I think somebody read ahead of you on the slide. And what platforms require a power of attorney as opposed to the attorney just telling them that you have authorization to act on behalf of the client?
Sure. So TikTok requires a power of attorney, and Instagram has recently been requiring either a power of attorney or a communication from from a representative of the company in instances where the relief being sought is transfer of the handle. So when you're submitting a trademark infringement report, let's say this is for an account that is using your trademark in the username. When you submit the report, you can request either that the account be disabled or that the account be transferred to the owner of the trademark. So this has been a fairly new development that we've seen with Instagram. They previously required a power of attorney. They more recently requested a communication from the rights owner itself, confirming that outside counsel is authorized to act on their behalf and to receive the handle that includes their trademark. So those are instances where we've seen the additional requirement. Okay, so continuing with social media and third-party marketplace enforcement, trademark reports require use for commercial purposes or logo use. We have found that a personal account that isn't clearly making a commercial use may still be vulnerable to a trademark infringement report if they're using the client's logo as a profile picture, or in other words, a design trademark as the profile picture. As I just mentioned, often with trademark reports, this will result in the disabling of an entire account, or when requested, could result in transfer of an account to the rights owner. And that's only available when the complaint relates to a username as far as transfer of the handle. Reports including links to multiple posts of counterfeit products often result in removal of an account for repeated violations of the platform's terms of use. So we found that, the assumption might be that you have to submit individual reports if you want to fall into this sort of multiple violations category, but that often including multiple violations in a single report has the same effect. With regard to copyright infringement reports, there is no requirement to show commercial use. You do typically need to provide an example of the work online, which again can be through your own social media or your website, or if the work is not published online, if it's in a magazine or you just have a physical copy, you can also upload that to most of these forms. One downside to a copyright infringement report is that it typically results in only the individual post being removed as opposed to the suspension of an account. But as mentioned above, we found that when there are repeat violations, if we ask the platform to completely disable the account, they typically are willing to do so. Most third-party marketplaces also have similar infringement reporting mechanisms for brand owners to submit infringement reports, typically trademark and copyright. For these third-party marketplaces, you often need a discrete purchase of the products being offered for sale in order to confirm that the product is counterfeit and not a resold genuine product.
And another question has come in asking us to talk just a little bit about what's the mechanics of a discrete purchase. And that's actually a simple question or with a simple answer. Usually we have, it's either, if it's our law firm, we have an in-house capability of making purchases so that the seller has no idea that they're selling it to a law firm. It's just it's just another customer. And if you're trying to go for, if you think it's going to be your discrete purchase is going to lead, that might be used in litigation, then there's more sophisticated ways to purchase discreetly where the chain of custody is documented thoroughly. Then it can be linked back to the seller. So that's the answer to that question.
Thanks, Gary. And I also wanted to add here, with copyright infringement reports, we've also had a lot of success with secondhand resellers like Depop, Tradesy, and Poshmark, where sometimes a user will upload a copyrighted image of a product that they are selling, typically an authentic product. They are just reselling it on one of these platforms. And if they use the original copyrighted logo of, for example, clothing, the model wearing the clothing, we've had a lot of success in requesting removal of those listings as well through copyright infringement reports. And one other cleanup that we often will do if the client is interested, this again relates more to infringing products as opposed to counterfeits where, if they're just stealing a copyrighted image. We'll also often do a cleanup of Google image search results to completely wipe off the internet any record that this infringing product ever existed. So you can contact Google, let them know that the listing has been removed, the product is gone, and they will clean up the Google search results. So another tactic that we often use are Digital Millennium Copyright Act or DMCA takedown notices. For a DMCA takedown notice, this relates to the unauthorized use of a copyrighted work. What we often see are copied portions of websites or product photographs that are posted to a website without authorization. Again, for copyright, there's no commercial use requirement, but the downside is that this will often result in removal of the infringing content only. That being said, what we typically find is after a DMCA takedown notice is submitted, the website will be deactivated, and if the owner removes the infringing content, for example, if it's just 2 photographs that were used without authorization, they can remove those photographs and then the website will be reactivated if they ask that it be. But also sometimes once you knock them down, they don't bother getting back up. Also with DMCA takedown notices, multiple violations will often result in account suspension. So little background on the DMCA. The DMCA creates a safe harbor that shields service providers from having to pay out monetary damages for their users' infringements of copyright. And in order to benefit from this protection, service providers must comply with notice and takedown procedures that allow copyright owners to quickly remove infringing content.
And
we found that this is...
And if you don't mind, and say the DMCA can be one of the most efficient and cost-efficient ways of addressing an infringer if the infringer has cooperated by literally copying an image or copyrightable material from your website. And there's nothing else you can do. Because when you do submit a DMCA letter, you do not have to prove that you have copyright rights in the subject matter, but you do have to swear, sign an affidavit, and usually the client signs that they're the copyright owner, and that is sufficient for the ISPs to take it down, and so it can be most efficient. Now, that does raise a little bit of a potential liability if you claim you have a copyright ownership in the subject matter of the objective use, and then it turns out you don't. The alleged infringer gets taken down, and you. And they sue you, and you can't prove that you're the copyright. There could be liability for monetary loss from the online absence after their website was taken down. But while that's a potential, it doesn't. In my experience, I've never had that experience happen. Never, but it is there. So you don't want to be running around claiming you have copyright ownership when you don't. So that's the takeaway. And that question is coming in. about the success of non-U.S. based ISPs when you submit a DMCA, because DMCA is a U.S. Law, but it often works for ISPs outside the country, and that falls under the category of it doesn't hurt you at all to ask a non-U.S. ISP to take something down with a DMCA takedown letter, because you give them the opportunity to say yes. And in our experience, they often do. Even though everyone here could make an argument as to why they shouldn't, they often do. So that's back to you, Sami.
Thanks, Gary. Yes, so for standalone websites, a DMCA takedown notice to the service provider or the owner of the IP address on which the website is hosted is often the most effective tactic for submitting a DMCA takedown notice. In order to submit a DMCA takedown notice, you need to first identify the IP address, which is available through public searches, or we have particular software that will quickly pull up an IP address, the IP host, and the DMCA designated agent who all DMCA takedown notices should be sent to. If you're doing this sort of the old-fashioned way, looking up the IP address, the DMCA designated agent is listed through the Copyright Office website, and that is who the takedown notice is then sent to. We've also found that contact information is often available at the IP host's website, for example, in the terms of use, and that will include preferred methods for submission of DMCA takedown notices. Some of the bigger ISPs will have their own form that will often result in even quicker resolution. Others still prefer the submission of a letter. And another tactic that we'll sometimes use, which can, again, be really effective with non-US based ISPs, is to do a quick search of their terms of use for their copyright provisions and point out, in addition to the DMCA violation, that the user is also in violation of Section 3.2 of the terms of use, or whatever the relevant section is. And so for this additional reason, you should remove the account and or the website. With regard to third-party platforms, DMCA takedown notices are typically sent directly to the platform as opposed to the ISP host. As an example, if you find one of your copyrighted images on Amazon, you probably don't want to submit a DMCA takedown notice to the IP host for Amazon to try to take all of Amazon down. No one's going to be happy at the end of that. So again, most platforms have their own provisions for copyright notices, and that again typically is a form that is submitted, like Amazon, eBay, as well as a lot of third-party platforms in other countries. Made in China and Alibaba also have their own platforms. So this again is a really effective way when you identify a single listing or a single account that is using your copyrighted images on a third-party platform. So Gary spoke briefly about the flexibility in asserting copyright protection in various works. Another creative approach that we have seen for creating the opportunity to submit a DMCA takedown notice is that brand owners who use creative logos might want to consider registration of the logo so that DMCA takedown notices can be submitted anytime their logo is used without authorization. Particularly on fake websites, we'll see this come up where maybe they didn't copy the entire website, but they just copied the banner of your website, which would have in theory, a logo, and that might, if you have a reasonable basis for alleging copyright protection in that logo, that can also be a basis for submitting a DMCA. So we have a few examples of different logos that have been deemed to be copyrightable. The Copyright Office has a general policy against the registration of logos, but under the Copyright Act, artwork that contains sufficient originality and expressive elements can provide sufficient authorship for protection.
And I'll jump in here. It's my experience that the Copyright Office does have. It's just a policy. It's a Copyright Office policy. It's not based in a statute. It's just a policy. They don't like logos, and so I believe all of these logos that we're looking at were deemed registrable after a fight and some kind of a court decision, and so you can always, if you get your logo registered at the Copyright Office, then it becomes a very powerful tool to take down infringing uses and infringers via DMCA. But say you apply for your logo at the Copyright Office and they deny it, you can still file a lawsuit against someone else alleging copyright infringement of your logo and make a review by the federal court of the denial of whether your logo has sufficient registrability. And you can make that part of the lawsuit, and the Copyright Office has an opportunity to join in to argue that no, it doesn't. And then the federal court would become the decider of that issue. And that's clearly doesn't fall into the category of cheap and expensive ways to go, but that, as long as we're talking about logos, I thought I'd throw that into its context. So that's all I have.
Thanks. Okay, so our next topic are domain disputes. Infringers will often attract users to a website by relying on click-through advertisements and an expectation that consumers will never see the domain name on their mobile device. I've seen this through Instagram advertising, for example. You click an advertisement and you get a pop-up, but you never really see what website you're actually browsing. And also creative domain names. For another one that comes up often will be the use of a capital I replacing a lowercase l, which is typically not detectable even to someone who is reviewing the domain name for the website that they're visiting. We often see websites pop up as phishing websites that purport to offer products for sale but never fulfill orders. So someone will find a product that they want to purchase, put it in their basket, and at checkout, they provide their full name, their address, their phone number, their email address, and credit card information, submitted off into cyberspace, and then no product ever arrives at their door, and they've given away their credit card information and extensive contact information, which can wreak a lot of havoc. We also see counterfeiters popping up trying to sell their products, tricking consumers into thinking that they're purchasing authentic products. So as I mentioned, infringers will often use domain names that are similar to the brand owner's name or their trademarks to make it more difficult to detect that this is an illegitimate website. So a great option when you have a domain pop up that is confusingly similar to one of your trademarks is to use these condensed domain name proceeding disputes, the primary of which is the Uniform Domain Name Dispute Resolution Policy, or the UDRP, which covers the vast majority of domain names.
Yeah, and I'll jump in. Clearly, you can't go after, and clients never do, go after all people who register domain names that include their trademark. It's generally what happens if you go to the website or the link, and if there's nothing there, most clients don't bother with it because it's no harm, no foul. If you go there and it's a counterfeiter, definitely they take action. You go there and it's not a counterfeiter, but it could be a competitor who's registered your domain name, so to trick consumers into coming to their website, and then they can buy the same product, but it's not your product, even though they were looking for you to begin with. then people tend to take action. What's interesting is if you go to the link of the website and it's like it goes to a click-through, that's kind of a gray area. Some clients are upset. People can go there and click, and then you go to another competitor, but it's an extra step that needs to be taken. Some clients go after that, and some don't. So just because someone is registered, put your trademark in a domain name doesn't necessarily mean that the decision is made to go after it. But so anyway, back to you, Sami.
Thanks, Gary. Thank you. So for a UDRP complaint, the mark owner is required to prove first that the domain name is identical to a trademark in which identical or confusingly similar, sorry, that's missing from the slide, identical or confusingly similar to a trademark in which the complainant has rights. You also must prove that the registrant has no rights or legitimate interests in the domain name, and that the domain name has been registered and is being used in bad faith.
Yeah, and I'll jump in. The domain name must be identical. What that means is trademark.com. That would be deemed identical. Now, as opposed to confusingly similar, trademark shoe.com. That would be confusingly similar to your trademark. And I'm using the trademark as in a generic sense there. That stands for whatever the client's trademark is. And I'll also jump in on that the third prong, the domain name has been registered and is being used in bad faith. Now, this is probably a good practice pointer for why a client or anybody should never, ever, 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 ever allow someone to register a domain name that has your trademark in it other than the trademark owner, because it's the registered and using in bad faith. Most of the time, people register and start using in bad faith if they're going to do that. But there is a situation that is not completely uncommon where, say, the trademark owner allows someone to register their trademark because they don't know how, they just trust the person. And so someone else is registering all their domain names that include their trademarks that they think that they want and they think are important. And that's great until, everybody's happy. And it's great until it's not great, until there's a dispute between whoever owns the trademark, the domain names, the registered domain names, and the trademark owner. And then the person who owns the domain names splits from the company and starts using it in bad faith. The UDRP requires the registration in bad faith and use in bad faith. In that situation, someone has registered the domain name with your trademark, not in bad faith. It was in good faith because you knew about it. And then it's only later on they started using it in bad faith after a dispute between the parties arises. That can prevent you from getting your domain name back in a cost-efficient manner. So take away from that. Never, ever, ever let anyone register a domain name who is not the trademark owner. Anyway, back to you, Sami.
Thanks, Gary. Okay, so UDRP proceedings are not available for all domain names, but they are available for all GTLDs or generic top-level domains. So those are the ones that we're all used to, .com, .org, .net, etc. And UDRP also applies to all new, quote-unquote, new GTLDs, which would be like .pro, .shop. These are released by ICANN, the Internet Corporation for Assigned Names and Numbers, still on a fairly regular basis. There currently are about 1,200 delegated strings, I believe. So like .science is another one. Those all fall under UDRP proceedings. A UDRP complaint can be filed with WIPO or with the National Arbitration Forum, and typical resolution is achieved within 1 to 2 months.
And I'll jump in. And just for context, between Sami and I, we often team up and we file UDRPs. And the two of us, we've filed over 200 of these as advocates for clients. And I personally am a domain name arbitrator for WIPO, and I've been invited to issue arbitration opinions on the ownership disputes of the domain names in over 100 cases. So we know the UDRP process and the ins and outs fairly well.
And one other comment on domain disputes, for domain names with CC, TLDs, or country code top-level domains, not all of them have adopted the UDRP. Two examples are .us and .de. But not all, but the vast majority of these CC TLDs have their own separate dispute resolution policies that are very similar to the UDRP. And those disputes are governed by the respective registration agreements. But again, for most domains, a UDRP or a similar domain dispute policy is available. And actually, I don't think I included it on a slide, but the remedies available following a UDRP are either transfer of a domain, or you can ask that the domain be canceled. Typically, we'll ask for transfer of the domain to the rights owner, who then will hold it in a portfolio to prevent others from registering the domain again in the future.
Yeah, I find that interesting. I don't, of all the UDRP complaints we filed, I don't think I've ever requested that the domain name simply be canceled. Although I imagine there are some sort of situations where you might want to, but we never do. And then when we do win, and we usually win, but when we do win, we take, the law firm takes over control of the domain name during a transition period, and eventually will then transfer the domain name to the client's portfolio. So there's a technical steps in between on how which we don't need to get into in this presentation, but that's all.
So the last topic that we wanted to touch on today that brand owners can proactively take advantage of during the pandemic is educating consumers. We recommend that brand owners consider developing campaigns that educate consumers in identifying counterfeits from real products. This kind of look for advertising can be particularly useful for marks that are not yet registered, and can also help to promote brand integrity. Educating consumers on qualities of products, for example, whether they're sold only through authorized retailers, can help equip consumers with information that helps them avoid purchasing counterfeit products, and also develops trust in the brand. So it can be a good move from a PR perspective. So we have a couple of examples of things that have popped up recently. One of my colleagues forwarded to me this advertisement that she found on Facebook. It's for puzzles that have been popular during the pandemic. A lot of people staying at home with more time on their hands. And so the brand owner was made aware of these products. It's my understanding that this is more of a copyright than a trademark issue, that they weren't using the branding of the owner, but that they were selling counterfeit puzzles that include the same image. So the brand owners have this side-by-side of what their authentic products look like, reminding owners of the brand names that they use, and warning customers to purchase the authentic products. Another interesting development during the pandemic has been the significant increase I mentioned earlier of counterfeit masks being imported into the US and sold online. I checked a few days ago, and as of earlier this week, 3M has instituted 18 lawsuits, primarily against sellers on Amazon, addressing the sales of fake goods, bearing the particularly N95 respirators that are sold by 3M and counterfeits are being offered to people looking for PPE during the pandemic. They've also seen issues with sellers offering for sale damaged goods and price gouging. So this is an example of one of the 3M campaigns to help educate consumers. Another interesting approach has been from the United States Patent and Trademark Office and the National Crime Prevention Council, which have recently implemented programs to try and engage consumers and brand owners to help identify counterfeits with their campaign called Go For Real. So using the hashtag Go For Real and a variety of marketing kits, the USPTO and again the NCPC have been working together to try and provide content that again consumers and brand owners can use to just sort of remind their prospective purchasers that counterfeits are very real and can cause serious issues. So that concludes our presentation. We have some time for questions and answers. If we have any other ones, we can run through those.
It's my understanding that people can simply type questions, and if anybody feels so inclined, we'll see if we can answer the questions. And if not, then we all get to move on with our day. So Sam, I'm not seeing any questions come in, are you?
I have not. So you can maybe wait another moment or so. Oh, okay, here's one. Okay, so we've been asked, do you recommend using a service like CSC to assist with challenging infringers? So this might be one of the difficult parts of not being able to interact directly with a follow-up question. We do work with CSC. A lot of our clients hold domain portfolios with CSC. And so, you know, we work often with them when we succeed in a UDRP proceeding. We also will often use them if we want to try to make a secret purchase of a domain name prior to escalating to a UDRP. Do you have any other thoughts, Gary? Or
no, we don't. If we're going to force the transfer, if we're going to make an attempt to force the transfer of ownership from whoever owns it to one of our clients, we do that ourselves. So to the extent that answers the question. That's the answer. It's after, like Sami said, after we wrestle away ownership of the domain name is when we interact with CSC to make sure, assuming the client owns or has the CSC managing their domain name accounts. Then we make sure that we funnel the domain names into that portfolio. And I believe we have used CSC to make a discrete purchase. So that is another way of the domain names. So that's, I think I saw another question come in.
Yeah, and if that didn't answer your question, please feel free to clarify, and we would be happy to address it. Okay, so we also have, how quickly do social media takedowns happen? In our experience, pretty quickly. Again, that might depend on how straightforward the case is, but I would say typically within a few days. Fastest I've gotten has been same day. If I submit an infringement report in the morning, sometimes it has been acted on by that afternoon. I've typically found that when the infringer is located outside of the U.S., it does seem like that is then sent to a team dealing with that jurisdiction's reports, and sometimes those will take a bit longer, but it's really rare. I think never more than a week, at least in our experience. Would you agree, Gary?
It happens very fast, like a day. When these things get resolved within a day, I'm not surprised anymore. And if it takes a week, then it falls into the annoying category.
All right, we have another question. As to counterfeiters located on Amazon.com, any recent new enforcement developments? So one thing I can comment on, although most of our clients do handle the Amazon brand registry directly, but I know that Amazon has implemented the brand registry program to help trademark owners with brand integrity through Amazon. Again, that has been something where our clients have handled it directly typically, but I know that they have seen positive results. And again, we have still been seeing that, at least in the trademark and copyright side, that submitting takedown notices to Amazon, it does tend to be effective. Do you have any other thoughts, Gary?
No, in the brand registry, you mentioned that once the trademark is registered with the Amazon brand registry, I really recommend that because it's cost effective, and then you're not bringing us into the that slice of enforcement activity, whereas that Amazon becomes your advocate to a certain extent. And then, once you do that, then they're operating and they'll take care of some of the infringement that's going on. And that is very cost effective. And I highly recommend taking full advantage of that.
Okay, so I don't see any other questions. We can hang around for another minute or so. If you have anything else that you want to submit, we want to thank you all for attending. Hopefully you got some new information out of this and enjoyed it.
Yeah, likewise. Thank you for attending, and hopefully we entertained you and educated you simultaneously. Seeing no more questions, why don't we just sign off and move on to what's next.
All right. Thank you all very much.
Thank you very much.